In this lecture series, we're going to be looking at the topic of rights and public policy. As we start talking about this, the biggest question we have to deal with up front is, what are rights? And our answer to that question is incomplete. Answers to this can vary dramatically, and many people's notions of what constitutes a right are irreconcilable with other people's notions of what constitutes a right. For example, this image represents a poster for human rights that was put out by a public library somewhere. We have the right to freedom, peace, equality, but also the right to food and an education. Things like providing education and giving people food as a right, however that would be implemented, it requires taxation. And for people of, say, a libertarian bent, like Murray Rothbard, we have the following thought: taxation is nothing but organized theft, and the concept of a fair tax is therefore every bit as absurd as that of fair theft. So his notion of property rights and being able to hold on to one's own money is irreconcilable with the idea that people have a right to food that government must fulfill, which would require taxing someone, right, or taking food from someone to give to somebody else. That leaves us with only the practical possibility of achieving some kind of tolerable balance within a society. As we are looking at rights, fortunately, we're not going to have you try to tackle those bigger questions. We're going to look at rights as they have been recognized in the United States. And there are two categories in the U.S. context: civil liberties, which, and here we have a precise definition because we need one: individual legal and constitutional protections against the government. As these are mostly negative rights, and it's been a while since we've talked about those, but remember, negative rights are essentially rights to be left alone, rights not to have the government interfere with what you are doing. The included positive rights we have in the United States, in terms of our civil liberties, are mostly there to ensure negative rights. And for example, the Fifth and Sixth Amendments that are there to make sure that if the government wants to take our life, liberty, and property, we must get due process. That's in the Fifth Amendment. As the government can't take our life, liberty, or property, that's a negative right, without due process. So the government can infringe on those rights, but only through due process. And the Sixth Amendment kind of lays out what that process looks like. You have to be given a jury trial. You have to be provided legal counsel. Those are positive rights. But again, they are present mostly to ensure the proper addressing of a person's negative rights if they have been accused of a crime. Our civil liberties are found primarily, and especially as we will be talking about them, in the Bill of Rights, in that group of the first 10 amendments. The second category are civil rights. And again, here we need a precise definition: policies designed to protect people against arbitrary or discriminatory treatment by government officials. These are more likely to be positive rights. They require action on behalf of the government to fulfill those rights for people. Remember, that is kind of the essence of positive right. A positive right is the right to be provided or given something. It requires the government to actively do something, right, to fulfill those rights. Whereas a negative right mostly requires the government not to do something. And our civil rights are found in a wider variety of places. They are found in statutes or laws. They are found in court rulings. And they are also found in amendments beyond the Bill of Rights. Our focus in the beginning here is going to be on civil liberties and therefore the Bill of Rights. We will get to civil liberties rather later. As I said before, the Bill of Rights is the home of our civil liberties, and there have been some important changes over time that we need to address at the outset. We need to understand that initially, the Bill of Rights was only intended as a protection from federal government. The idea of the framers or the founders was that states were not what people needed to be afraid of. What we needed to be more concerned about was this newly created, stronger central government, and therefore we put restrictions on that government by spelling out this Bill of Rights. The understanding that the Bill of Rights was only a protection from federal government was initially enshrined by the Supreme Court in the ruling in Barron versus Baltimore in 1833. But nearly a century later in Gitlow versus New York, there was an extension of Bill of Rights protections to the state level. Now, this has not been wholesale. This has really specifically been for freedom of speech and press in the case of Gitlow, via due process, the Due Process Clause of the 14th Amendment. That Due Process Clause from the 14th Amendment states that no state may deprive any person of life, liberty, or property without due process of law, which is language that looks shockingly like the Fifth Amendment, but in the Fourth Amendment is expressly imposed upon the states. We also see something called incorporation doctrine, or sometimes referred to as the incorporation principle. And this has been a developing tradition of the Supreme Court, gradually imposing more civil liberties protections found in the Bill of Rights on the states. Again, none of this is wholesale. This is done on a case-by-case basis. It has been gradual. As we will see, it is not always in the direction of more restrictions on states and broader interpretations of civil liberties. But as a result of this, most of the civil liberties we find in the Bill of Rights are now protected from infringement by states. So we have incorporated states into those Bill of Rights protections. From here, we're going to start looking at specific civil liberties. And some of the time we'll be following kind of the order of the Bill of Rights. At other times, we may kind of get things a bit out of order. But we're going to look at freedom of religion, freedom of expression, freedom of assembly, right to bear arms, defendants' rights, and perhaps a right to privacy. So this is not going to be a step-by-step walk through all 10 amendments in the Bill of Rights, but we will examine each of those. Freedom of religion is, of course, found in the First Amendment, and it has two key elements. First is the Establishment Clause, and Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, the question that has not been entirely resolved is, does the Establishment Clause mean that the federal government simply cannot, or specifically in this case, Congress, cannot show favoritism to one particular religion, or does it mean that there should be a complete breakup, right, complete separation between the state, the government, and religion? And that debate goes back to the very beginning, with people like Thomas Jefferson arguing that there should be a complete, bright line separation between the two. So we're going to look more at this in terms of how it is actually kind of worked out historically and in the law. We'll start with one of the key areas where there's been dispute about the Establishment Clause, and that is in regards to schools. One issue is no prayer in school. And this is from Engel versus Vitale in 1962. This is an AP required case. We will come back to that in more detail, but if you remember that this is the case that prohibited prayer in schools, you're a long way towards knowing what you need to know. But we also have Abington School District versus Shemp. And this case is similar to what we see in Engel versus Vitale, as this is the AP required case, but it's not the whole story. The Abington School District case actually goes farther, because there was also a question of whether schools could sponsor readings of the Bible or recitations of prayer. So there are kind of two things in this case, and it comes about the same time. It's from 1963. Generally, I put dates with these, and I forgot in this case. More recently, probably before most of you are old enough to remember, not that this debate has entirely gone away, but there were questions about whether schools could teach intelligent design, the idea that some being created the universe and everything in it, as an alternative to teaching evolution, or taught alongside as an opposing view towards the theory of evolution. Lower courts have said no, and so far that's kind of where we are stuck. Right? But as things currently stand, public schools cannot teach intelligent design. And I should be clear that the no prayer in school also applies only to public schools. At the same time, this does not mean the shutting out of religious groups from schools. Student religious groups must have access to school properties if other groups also have access. And this is one of the cases where we see something that is not just from the Bill of Rights, but the Equal Access Act of 1984, which was upheld by Board of Education versus Mergens in 1990. Which is why, like me, you sometimes arrive at school early and you've seen student groups doing Bible readings or prayers in the hallways. This is something that they can do because of that act and that Supreme Court decision. At the same time, student religious groups may be required to allow people who don't share their religious beliefs, right, or people who share different religious beliefs to join in their groups and participate. And this is, at this point, I mean, as far as I understand the jurisprudence, this is a matter of state-by-state law on what student religious groups must do, but the authority of states to pass laws that would require student religious groups to allow non-believers to join is found in the Supreme Court case Christian Legal Society Chapter versus Martinez from 2010. Continuing on the topic of schools, there's the question of federal funding for parochial schools or religious schools. And here, things are kind of in flux. So until recently, federal funding could be used for parochial schools, but only if the funding was not used to further or oppose any religious teaching. This was Lemon versus Kurtzman in 1971. We also have different topic of state vouchers for parochial school tuition, the idea that the state governments could give people vouchers that they could use to pay tuition for parochial schools. Those are okay as long as the recipients of state vouchers for private education are not required to pick a religious school. If they could instead, say, go to a secular private school, which I know those in the St. Joseph area we don't really have, but I mean, they exist in places not far away like Kansas City. So if people have a choice Right? If they're not required to pick a religious school, then it is okay for state vouchers to be used for that purpose. And that comes to us from the Zellman versus Simmons-Harris case in 2002. Here, we're going to step back from schools and look more broadly at federal funding for religious activities. There's another area where things are in flux. Until 2002, the answer was yes, if they passed the Lemon test. And the Lemon test refers to Lemon versus Kurtzman, right, and also the endorsement test. So let's talk about the Lemon part of this first. So the Lemon test is for compliance with the Establishment Clause. And if these questions could be answered the right way, then the federal funding could be used. So is the federal funding for religious activity meant to achieve a secular, i.e. non-religious purpose? If yes, we're on our way to being approved. Does the effect of that service predominantly have a secular effect? If yes, then we've satisfied the second requirement. And 3, and this is the fuzzier bit, does it avoid excessive entanglement between the government and religion? So you might think here of federal funding for a religious soup kitchen to provide food to people who don't have it. And providing food is a secular purpose. If it leaves hungry people feeling less hungry, then the effect is predominantly secular. And if it does not excessively entangle the government and religion, and then it's okay. So let's say that the religious soup kitchen does not ask anybody about their faith. It does not ask them to pray for their meal. I don't mean that as like pray in order to get the soup. I mean like say grace or something for their meal. Then that might not be excessive entanglement. And the endorsement test refers to the idea that the government is endorsing a particular religious viewpoint or denomination. So in other words, just endorsing religion. However, after 2022, things have changed. In Kennedy versus Bremerton School District, the Lemon test is gone, and the endorsement test, which is kind of seen as an offshoot of the Lemon test, is gone. The court has instead adopted a new standard, which is federal funding can be used for religious activities if it is in line with the original meaning of the Constitution and the framers thinking about it, right, and historical practice. So as you can guess, this is kind of a fuzzier standard and leaves more room for federal funding of religious activities. From there, right, we go from the Establishment Clause to the Free Exercise Clause. And what we do have, very outset, the right of a person to believe what they want to believe cannot be violated by the federal government. However, the right to practice one's religion, that may be regulated. Now, federally, this is subject to 1993 Religious Freedom Restoration Act, which is meant to keep the federal government out of regulating a lot of religious practice. Any regulation of a religious practice, right, has to be narrow, so this has to be very tailored to what the government is trying to achieve. It must serve a compelling interest, and compelling interest is, in quotations, it is also, that is the exact phrase, it is also very important. The government must have a very, very good reason, right, to be trying to regulate the practice. So, for example, I mean, if a religion practices human sacrifice, and the federal government obviously has laws against killing people, and other levels of government have laws against killing people, you can prohibit that. It has a narrow interest. or it's narrow. It is to prevent people from being killed in the name of religious practice, and as it prevents murder, it serves a compelling interest. The states are a different story. In Employment Division versus Smith of 1990, the Supreme Court said that you can regulate religious conduct as long as it is only the religious conduct that you are trying to regulate and not its religious nature. So, going back to that example of human sacrifice, we are only regulating the conduct of killing people. We are not regulating the conduct of killing people because we oppose that religious belief. We prevent the law is meant to prevent everybody from murdering other people, regardless of why they are committing the murder. In this case, it was about drug use, and that the government was trying to regulate drug use, not because the drug use was religious, but just because the state wanted to regulate drug use in general. And here there are some kind of important examples and cases that we need to examine. The first is because for those of you who will be taking the AP exam, this is an AP required case, Wisconsin versus Yoder in 1972. And this case is important because, in terms of who it affected, it's narrow. It's a small, very small slice of the American population. But this case said that Amish children are exempt from being required to go to school after 8th grade. In most places, you have to attend school until you are 16 or older. But in this case, the Amish argued that sending children to school past 8th grade conflicted with their religious beliefs. And the Supreme Court ruled that, in this case, the rights of the people, the Amish people, to practice their religion, even if that meant pulling them out of school, was more important than the consequences of those children continuing their education. And this, in some ways, is pretty narrow. The Amish were singled out as exempt from compulsory education after 8th grade because they were a long-standing established community whose religious beliefs were traceable back a very long way. And because of the nature of Amish society, it was very unlikely that Amish children, even if the rest of society would see them as undereducated, would become a burden on society, because Amish communities are rather self-sufficient and look after their own. Their kids are not going to end up requiring a lot of government support later in life because they left school after 8th grade. But this does show kind of the importance of the exercise clause and its implications. Conflicting specifically with a state interest in educating all children up until, again, the age of 16 or later. We also have West Virginia versus Barnett in 1943, and this is kind of a mix of, in some sense, freedom of speech and free exercise of religion. Jehovah's Witnesses may refuse to say the Pledge of Allegiance in schools, and because Jehovah's Witnesses, their religious beliefs do not permit them to pledge allegiance to a government or a state. This was part of what led to their persecution by the Nazis in Germany, and in this case in the United States. It was decided that their religious freedom overrode any school interest or state interest in having students recite the Pledge of Allegiance. More recently, and in some ways perhaps more important, at least for people right now, and more widely across the United States, the decision here is that family-owned corporations, and it is important to note we're talking about family-owned corporations that are run along religious principles. Okay, so their owners are very clear about their faith and how their faith influences the operation of their business and what they expect from their employees. Such family corporations are not required to participate in insurance programs for their employees. that provide contraception. And this is an issue because in the Affordable Care Act, or Obamacare, there is a mandate that businesses, corporations with more than, I believe it was 50 employees, were required to help provide insurance that included insurance coverage for contraception, things like birth control. And in this case, the Supreme Court ruled that those religious principles outweighed the government's interest in providing contraceptive coverage. And so this is partly important because it extends free exercise clause into the workings of corporations and their relationships to their employees. And this is also, it's tied up in a lot of other things, but that's a very important case and much more recent. From there, we're going to go to freedom of expression. And this is a consistently contentious topic. We have two categories of freedom of expression, and in this lecture, we will only get to deal with the first. We will, of course, pick it up in the next lecture. The first category is speech. We need to understand that political speech and acts of symbolic speech, things like carrying protest signs, for example, are protected, including controversial things like flag burning. That would be clearly an act of symbolic speech. That was upheld as a constitutionally protected form of symbolic speech in the case of Texas versus Johnson, 1989. But you cannot engage in political speech or acts of symbolic speech that incite people to violence, especially violence against the government or with the goal of overthrowing the government. We get a second mention of Gitlow versus New York here. This would also be a good time for me to throw in some of those attention checks that I've been forgetting about this time. Let's see. Let's go with zebra, tulip, and granite. There can also be limits on speech if that speech threatens the public order. And this is something we see in another AP required case, Schenck versus United States, 1919. Of course, in this case, it comes out of World War I. Schenck was advocating that people refuse to participate in the draft. And the Supreme Court ruled that, especially in wartime, something that represents a clear and present danger is not protected speech. This is the clear and present danger test, for example, and is laid out in kind of the opinion of that case, is the reason that a person is not allowed to falsely yell fire in a crowded place like a movie theater. And in this case, what the argument was someone advocating against conscription or arguing that people refuse to participate in conscription during wartime constituted a clear and present danger to the effectiveness of something that Congress needed to accomplish, which is providing troops to fight in a major conflict. Switching to what seems like a very different topic, money is also speech, or at least can be. In this case, if it is spent to influence elections. We think about these through a lot of more recent cases, and we'll talk about those, but the first one to talk about is Vallejo versus Buckley in 1976. More recently, and this is the AP required case, Citizens United versus FEC, or Federal Elections Commission, in 2010. And the idea here is that people and corporations can use their money to influence elections, that money is a form of speech, and to limit their ability to spend that money to influence elections is an infringement on their right to political speech. Some of this also raised issues of the corporations as people question, It was treated kind of as a new thing in the media, but the idea of treating corporations as people goes back about 200 years. On the other hand, other speech is subject to tight limits. So commercial speech, things like advertising, for example, are subject to regulation by the Federal Trade Commission. And as you're writing your notes, I would encourage you to write that out just so that you make sure you know what FTC means. And if it is commercial speech specifically on television and radio, this would be very much especially, I guess, sorry, I'm using a lot of especiallys, in the case of broadcast TV and radio that use public airwaves to carry messages. Those are regulated closely by the Federal Communications Commission, or FCC. And other forms of speech are just absolutely not protected and are likely illegal. So defamation, right, false speech that harms someone's reputation, it's libel if it's written, slander if it's spoken, fraudulent speech, so trying to commit fraud, and obscenity are not protected. And we'll come back to the obscenity issue when we talk about the next part of freedom of expression, and that is with the press. But we're going to, for today, stop here.